I hope I can synthesize the things I want to say, because there are so many things under this umbrella of criminal investigation, and more or less there are sensitive things. First of all, let me thank you in the names on behalf of let's say Oradea team. Let me thank you for the invitation and for the fact that we are part of this second Hercule project. We have prepared an overview, both from substantial and procedural point of view. And we will like to highlight in the second part of our presentation some procedural aspects that are connected to the investigation in this field. I would like to share. Please tell me if you can see the slides. It's okay. I hope it's okay. First of all, what is the premises for our endeavor? We have the treaty to access for Romania's accession to the European Union in 2007 in force. Since that moment, we have deposited, let's say, a lot of effort in order to achieve what we are calling the communitary acquis. As one of the results is the law 78 from 2000 that was adopted in 2000 and was more or less one of the first instruments in countering or combating acts against the financial interest of European Union from criminal law point of view. However, in that context, the Romanian legislator has underestimated one of the most important problems which has overall affected the Romanian law system over the last 30 years, namely the normative excess. I will make some details. I will present some details around this matter. Furthermore, I would like to underline that the direction assumed by our country was to transpose into the national legislative system numerous regulations, directives, including those related to the protection of the EU financial interests. As a consequence, as I said before, we have the law 78 from 2000, which deals actually from the title with corruption. And within this law was included in section 4, index 1, were included the offenses against the financial interest of the European Union. So they were not included in the law from the beginning. They were included a few years after the initial adoption of the law. We have 3+1, let's say, offenses here regulated, and I will present them in short, not to deep into the analysis, since our main concern is at this moment the procedural aspect. So we have Article 18, Index 1, the use or presentation of false, inaccurate, or incomplete documents or statements if the deed results in the unjustified obtaining or unjustified withholding of funds or assets from the budget of European Union or the budgets administered by European Union or in its behalf, shall be punished with imprisonment from 2 to 7 years. Initially, the punishment was more severe, from 3 to 15 years, but over the years it decreased up to this level. This level has a significant, is important from procedural aspect, since up to 7 years, if the crime is punishable up to 7 years at that time, at the 2000, then a plea bargain could have been concluded between prosecutor and the defendant. Furthermore, in the next paragraph, we have the same punishment which sanctions the omission to provide knowingly the data required according to the legal provisions for obtaining or withholding funds or assets from the budget of European Union or the budget administered by it or it on its behalf, if the deed results in unlawful obtaining or retention unjustifiably of these funds or assets. And the last paragraph deals with particularly serious consequences. This means consequences in the value, in the amount of approximately 400,000 euro. Furthermore, we have article 18 index 2. The change without observing the legal provisions of the destination of the funds or assets obtained or retained from the budget of the European Union or from the budgets administered by it or in its name is punished with imprisonment from 1 to 5 years and prohibition of exercising certain rights. Also, we have another offense, the change without observing the legal provisions of destination of obtained legal benefit, if the deed results in an illegal diminution of resources from the budget of European Union or from the budget administered by it or in its name, it is sanctioned with the same punishment provided in the previous paragraph. The last one in this chapter of the law, we have Article 18, Index 3, which is more or less similar with the first one I have presented. The use or presentation of false, inaccurate, or incomplete documents, which results in the illegal diminution of the resources to be transferred to the budget of the European Union or to the budget administered by it or on its behalf. So the main difference between Index 1, 18 Index 1 and 18 Index 3 is the fact that in the last case, we have the resources, the protection is the object of the protection are the resources to be transferred to the budget of the European Union. Also, it is sanctioned as a criminal offense, the omission to provide knowingly the data required according to the legal provisions. If the deed results in an illegal diminution of resources to be transferred to the budget of European Union, the budget administered by it or on its behalf. A total, let's say, novelty in our law, especially criminal law system, total novelty is connected with this next offense we are presenting, 18 Index 5, which is from subjective point of view has a different approach, since we are dealing here with a faulty violation committed by the director, administrator, or the person who has decision or control within an economic operator of a duty of service, but its non-fulfillment or its defective fulfillment, if the deed resulted in the commission by a person who is under his subordination and who acted on behalf of that economic operator of one of the offenses provided before. Here is a little mistake in Article 18 Index 1 up to 18 Index 3, or committing a crime of corruption or money laundering in connection with European Union funds. We have the sanctioning here, imprisonment from 6 months to 3 years or a fine. I want to get back to the first offense I have presented. We had a dispute within the jurisprudence, and the dispute was solved, let's say, by the High Court of Cassation and Justice, that who established in 2020 that the person who commits both the deed presented in 18 Index 1, and since it includes the false and inaccurate complete of documents and statement includes forgery, the person who commits the offense stipulated in Law 78 from 2000 and the forgery stipulated in the Criminal Code is punishable for both offenses in real competition. So the High Court considered not to absorb the crime of forgery into the crime stipulated from Article 18 Index 1. Furthermore, if we are going to the procedural part of our presentation, then we must underline that the offenses provided by this law 78 from 2000, in case of these offenses, the criminal investigation must be carried out by the prosecutor. And also precautionary measures must be taken in all cases. There is no exception. We have a problem with that attempt, problem that was solved partially by the Constitutional Court, but we have, let's say, another problem today when we are the public ministry from Romania, who is overseeing the activity of the prosecutors, is dealing with the division of the case in between them, the National Directorate of Anti-Corruption, and the EPPO. Some special provision for detection and prosecution of criminal offenses. The person who has control attribution is obliged to notify the criminal investigation body in all cases. In all cases, he is obliged, he or she are obliged, they are obliged. Also, the person who is carrying out a control during the performance of the control, if he or she finds out some certain aspects that are connected sorry. I have to, I'm sorry. I did not see the messages on the terminal, sorry. On Hungarian. It's okay. Maybe now. I turned it out. Okay, I'm sorry. A misunderstanding. So I was saying that there are certain persons who have the duty to notify the criminal investigation body when they are aware of aspects that are connected with the protection of financial interest during exercising their duty, or more important, during the control. In the last case, they also have to take certain preservation measures as regarding the traces of the crime, as regarding the corpus delicti or the other evidence. Since I lost a few minutes, I will go a little speedier. Also, we have an obligation, a procedural obligation from the persons who are more or less in charge with the corporate and juridical entities, that they have also the obligation to notify the investigation body, or as the case may be, the bodies for ascertaining the commission of the crime, or the control bodies authorized by the law. When sums, goods or money that are supposedly influencing the protection of financial interest of EU are involved. more or less. One of the most important provision from this law is that the banking and professional secrecy, except the professional secrecy of the lawyer exercised under the law, are not opposable to the prosecutor after the start of criminal investigation, nor to the court. For the trial in the first instance of the crime provided in the Law 78 from 2000, specialized panels are set up. For both of these aspects, we have strong debates in Romania. In the first case, for the expression exercised under the law and which are the limits of the defense you have to provide for your client as a lawyer. And in the second aspect, these specialized panels are very much debated also under the jurisprudence of Constitutional Court. Furthermore, if I have to can you hear me?
Yes, yes. Yes, we can hear you.
Okay. So I have within the presentation we have included a lot of technical data, statistical data. Maybe is not suitable for this late hour now, but I would like to underline some aspects. However, if we are looking for the plea bargaining agreement, as discussed in the session in the morning, in the last period in 2020, there were 46 plea bargaining agreements closed, 41 for natural persons and 5 for legal entities, for which the competent courts were notified. In this respect, there was an increase compared to the previous years in the number of agreements concluded, given the fact that in 2019, only 38 were registered, and in 2018, only 12 such agreements were registered. From this point of view, it is important to underline the significance of the Article 478 from Criminal Procedure Code, which denotes, we say, the efficiency of the way of completing the criminal investigation activity and of the strategy adopted by the prosecutors in order to avoid costly and long-lasting criminal trials. Unfortunately, also in Romania, we have trials, criminal trials that are lasting long, too many, not months, but too many years. If we are passing to the sources, what are the sources for investigation and prosecution? We can see that the offenses perpetrated within the branch of agriculture and rural development are predominant. In this respect, we had 63 cases last year. As regarding the modus operandi, the investigation of these crimes, of course, is a complex activity. In many cases, we have encountered a very well-developed way of operation, patented and replicated by the same people on the occasion of different requests for funds, establishing and interposition of companies controlled by the fraudulent beneficiary, or distortion of public tenders organized for the purchase of equipment in such a way that they were awarded at prices well above the market value, with the subsequent recovery through the fictitious contracts by the beneficiary of a price difference. These two are the most common methods of perpetration. Closing, I want to refer to a recent decision that affected, let's say, our presentation, since this is a decision from 18th of May 2021, which deals with the, let's say, reforms we have performed into the justice system in the last years of in Romania, in the last 3 years of Romania. There were 6 preliminary rules addressed to the Court of Justice from European Union, and one of them dealt with supremacy or primacy of the EU law, because there were decisions from the Constitutional Court or more from the Constitutional Court, not so many from the High Court of Justice, but from the Constitutional Court that were considered by certain judges not in accordance with the European law. And there was a question to what should they do? Because they, from internal point of view, internal rules point of view, they had to observe the decision of Constitutional Court. Otherwise, they could be held disciplinary responsible, or they will apply directly the European law. Summarizing, the Court of Justice from Brussels did say that they have, or they can, not they have, they can apply directly the European law. Final remarks. Recent decision I have mentioned, it's practically a change of approach. The investigation techniques must be updated to the means of perpetration. We have the problem of overlapping legislation, as in forgery and we have to have more clear procedures, enforceable procedure to actually recover the financial damage. In the respect of enforcing the EU regulation we have a new law from February 2021, which established a support structure to implement the decision and enhance cooperation as regarding public prosecutor office. With these remarks, I'm closing our presentation and I'm thanking for your attention. Once again, sorry for the mix-up of things in the beginning.